This conference will now be recorded.
Okay, so we're here. It's 11:04. There's no one in Village Hall.
Okay.
And I think we can just, so Rick, if you could say again that what.
I would make a motion that we postpone the meeting to the 2:30 time this afternoon.
Okay, and I second that. And
all in favor?
Aye.
Aye.
Yeah, I think we have to do a roll call, so I'll just say.
Okay.
Rick Montalto.
Aye.
And Allison Murphy says aye, so the motion passes. And I guess we just continue at 2:30. So.
Okay. I plan on being there in person at 2:30. So.
Okay.
Okay.
All right.
All right. Bye-bye.
So, all right. Thank you. We'll see you at 2:30, Mr. Meyer.
Thank you.
This conference will now be recorded.
Oh, Sean.
No, I mean, you're unmuted.
Okay. I cannot hear Sean. I couldn't hear anything Sean was saying. Can you guys hear me? Hold on. She's talking and I can't hear her either. Yeah, see, I can't hear her.
So anybody with the red is
I know it's muted. I understand that,
okay.
But Sean was talking and he was on green.
Yeah, but that's has nothing to do with
I'm
you.
unmuted. I know, but I should be able to hear him, right?
Yes, but it has nothing to do with you.
Oh, okay.
It's something on his computer.
Can you hear me?
I can hear Rick.
Okay. They're working on the sound right now. Laura,
okay.
Okay. Allison's in here working on Sean's computer now.
Okay. I just want to make sure I can hear and you guys can hear me.
Laura, are you on mute? We can't hear you.
Hello?
I heard somebody say hello, but there was a lot of background noise.
Okay, here's the deal. Can you all hear me?
I can hear you. I can hear you, Rick.
We're probably going to use my tablet. There's something going on with the sound on Sean's computer. The background noise you heard was feedback we were getting when my sound was on and they were trying to get his on. But if his is off and you can hear him, Sean, give a test now.
Okay.
Test 1, 2, 3.
Okay, can everyone hear me now?
I can hear
Yeah, I
Allison.
can hear Laura.
Okay.
Oh, wait, that's Laura. I'm sorry.
Yeah.
I can't see, but I can.
And hold on a second, make sure that my sound is all the way up. What the heck is my button here? If you can hear Sean, that's the key here.
I can start over. I'd like to welcome everyone. I'm Sean Weiss, Village President of Road. I am at 10 Municipal Drive along with Rick Montalto, who is our senior trustee. And then we're joined by Mike Scholas, who's also in attendance here, and his attorney, Jeffrey A. Meyer.
John, there's a lot of background noise, and I can't really understand what you're saying.
Okay. I can't understand what you're saying.
I mean, I hear your voice, but I don't hear the details.
I'm gonna crank it all the way up.
Okay.
Sean, get in and test, see if they can hear you now.
Testing 1, 2, 3.
Can you hear me?
Low. I mean, can you just hand him your tablet? Because you're perfect, Rick.
Well, that's because the tablet's right in front of me.
Can you put? Oh, you're at home? Wait, are you at home?
No, I'm at the village, but we have to stay social distance, so we can't be next to each other. We could probably let me move one chair over. See if that'll help, because I'm 3 chairs away from you.
Oops.
Okay. Try it again, Sean.
Okay. Thank you. Thank you for being here.
Just talk loud.
I'd like to call this meeting to order. 2:37. Allison, can you do roll call, please?
It's still not great for me. Is it great for everybody to hear him?
No.
Yeah, Laura's saying no too. I mean, it's bad.
All right.
Go ahead.
Sean's going to try and call in on his phone, and then I'll have to mute while he's talking so we don't have feedback.
Okay.
Gotta love these virtual hearings, right?
Yeah, right. The technology, it's amazing.
Well, the good thing is we can hear you all fine.
Good.
Dialed in. Okay, Al. Can you hear me?
All right, I'm going to
hear
mute.
All right, let's see. He was muffled.
Okay. Turn off your.
Where?
Turn down your speaker.
What money do you have?
Okay. All right. I apologize.
I still can hear nothing. I still cannot. There's background noise, and it's like again. But Allison's. Oh, wait, that's good. John? Oh no, that's good. I can hear you. I can hear you perfect now.
Okay. All right. And Rick will turn on the volume at his tablet. Okay. I'd like to call this meeting to order. It's 2:39. Allison, could you please do roll call?
Chairman Michaels,
Here?
Rick Montalto,
Here.
Okay. There's a quorum. The board consists of myself, Rick Montalto as the senior trustee, and Allison Murphy as our village clerk. I'd like to introduce Laura Julian. She is our village attorney and will be the attorney helping us out through this process, and she has some initial remarks.
Sure. And first, would you like to make a motion to appoint me as acting counsel for the Electoral Commission?
Okay. I'd like to get a motion to appoint Laura Julian as the attorney for the Electoral Board.
I will second that motion.
Roll call, please. Allison?
Chairman Michaels,
Here? And yes?
Trustee Montalto,
Aye.
and Allison Murphy, aye.
Okay, thank you.
Okay.
Okay, and can I go ahead then?
Please.
Okay, I just wanted to make a few introductory comments for everybody, and I know many of us have not had experience serving on electoral boards or appearing before electoral boards. So I just wanted to give a brief overview of the process to everybody. The composition of the board is such that members of the body that the candidate seeks to join are also members of the board that is overseeing this petition. And I know that sometimes people feel that this is unfair or they wish that others could serve in the stead. It's also uncomfortable for the people serving on the board because they're asked to rule on matters for people who will, more likely than not be their colleagues in the coming months. Just by way of background, serving on the electoral board is much like serving on jury duty, where there's a rule of succession set, the board composition is set by statute, and there's a few statutory requirements that would call for substitutions, but it's different than a village board or any other body where there's a lot more discretion with regard to who serves or who doesn't serve. So I did just want to make that clear to everybody because I know it does seem a little counterintuitive sometimes the way that the board is comprised. I wanted to also explain that there's a number of standardized rulings that do exist, and this is a tool that the board has at its disposal. This is set forth in the Illinois Electoral Board Manual, which in conjunction with consulting with legal counsel helps the board to assist and navigate the issues that come up. In many cases, during an objection proceeding, many of these issues have already arisen in other forums, and the manual that the board has summarizes both the state law and what the case law is on the issue. This does not mean that the electoral board does not listen to the arguments that come before it, and it doesn't mean that it disregards the facts of its particular case, because of course, there's distinguishing facts and every case is different, but it does set forth some basic rules to follow and what the standards generally are, absent, a showing that for some reason the case in front of this board is different than the law that currently exists. This is also done to help ensure that candidates have some, sense of fairness, whereas you would want somebody in this village to be treated similarly and have their petitions treated similarly as somebody in a different village. So that's the reason why these standard rulings exist. And, it's really just a tool for the board. As far as the law goes, the electoral board, makes a decision on what the law currently is, not what it wishes that the law were or what I believe is the most equitable in the case. So it's not making a decision on what it thinks the correct outcome is based on its personal beliefs, but rather the state of the law as it exists. So I did want to just make clear, that there are certain constraints that exist, especially with regard to these types of cases. As far as the hearing goes, as you all know, once the meeting is called to order, the meeting is being recorded, and then the next step will be that rules of procedure are adopted and that those will apply. Preliminary motions will be first. So if anybody has a motion at the very beginning prior to getting to the merits of the objection, that'll be heard first. At the next time, the objector will have the opportunity to present their case in chief, and then the candidate will have the opportunity to present their rebuttal. At the conclusion, the board will deliberate. They will do this all in open session, and they will talk through the issues, at which time they will give me a direction to draft a decision, and we will reconvene once that decision is drafted for the board to adopt. The role that I play is that I serve as counsel to the board. I'm here to serve as a resource for the board as to what the applicable statutory rules are and what the case law is, but it's the job of the board to conduct the hearing, to make the findings of fact, and to determine how the facts of this case fit within the law as it exists. And then just finally, one statement that I wanted to make, especially with regard to what's going on in Washington today, it's just really important for everyone to maintain civility and to really respect the process. And I expect, I know that goes without saying, but I just think it's such an important reminder right now, especially in light of everything that's going on. So with that, I will defer to Chairman Michaels to proceed with conducting the hearing.
Okay. Thank you, Lou.
So Sean, you're on my end. So there's a couple things. I again, and then I have, one question, two questions about what we're doing here going forward, and then I have a recusal question.
Okay. Let me first get a motion to approve the electoral board rules.
I can't hear you.
Hold on. Okay. Rick's muted.
Okay, that's better.
Can turn down your.
Oh yeah. Okay.
Okay. So I'd like to get a motion, or I'd like to make a motion to approve the municipal officers electoral board rules for the village of Sugar Grove as presented by Attorney Julian, and it is. It states the different powers of the electoral board, case management, order presentation, and the various rules that go before this board that we must follow. So I have a motion to approve this proposed rules.
I'll second the motion.
Second by Trustee Montalto. Roll call, please, Alice.
Chairman Michael?
Aye.
Trustee Montalto?
Aye.
And Clerk Murphy? Aye.
Okay. Now that we have those approved. Okay, Rachel, if you'd like to ask your questions, and if they're going to be considered towards case, we'll let you know. But
Yeah.
Why don't you state your questions real quick, and then we can decide how to proceed.
Okay. So the first question I have is regarding recusal. I sent in a formal request, both to you personally and to the village for your recusal. I'm assuming you understand the conversations we've had via phone, via email. I'm sure you've considered my request, and you're considering to move forward because you feel it's in the best interest of the people, and you do not feel that there's any reason to recuse yourself. I just want to make that clear, and I want it on the record.
And if I could interject, as I stated previously, the recusal question is a matter of statute. It's not something that's within the discretion of the members. So unless there is a basis that meets the statutory factors that would be recusal, which is typically that the person on the board is either a witness in the case or is running for the same office as the objector, or has a pecuniary interest in the outcome of the case, then, there isn't really grounds for recusal. It's not within the discretion. It would be an automatic disqualification.
Sure. So in my mind, it falls within the ability to potentially, just the ability to benefit. Listen, I'm sure he's discussed it with you. I'm sure he's discussed it with himself, and I trust his decision if he decides he's not recusing himself today. I just wanted it on the record that I made mention of it, and I'm sure he's thought it through, and that's totally fine with me. So that was my first question. My second question has to do with where do I prepared a very small opening statement, and I'm doing that for the 143 voters. I had an affidavit for my circulators last night, renotarized, and I just think it's important for me to speak on their behalf. It'll probably take a minute to a minute and a half, but I have 143 signatures from Sugar Grove voters and from my notaries were even Sugar Grove people, and they wanted to see me on this ballot to at least give me an opportunity to hear my platform. So I would appreciate the board's consideration and listening to my opening statement, and it has to do with my circulators and all the work that they did getting petition signatures and just all the rights of the registered voters within the village.
That could come during oral argument when you'll have a chance to state your case.
Oh, okay, so I will have an opportunity to have a prepared opening statement moment. That was my question.
Correct.
And then I have one more question. I'm sure it'll come up at some point in time, but I just wanted clarification on a document that I received from Allison and with the heading of the Sugar Grove on there. It was I have a question about the date that's on this document. If you're going to tell me that's later in the process, that's totally fine. I just want to understand. I just have a quick question for Allison, and that's it. That's all I have.
Okay, and that would also be part of the oral argument.
Okay.
Okay. Okay. I will call the docket, which is the case before us is Michael C. Shulmus, objector, versus Rachel Rockwell, the candidate. Case number 2020-MOEB-001. So that is the docket to come before us. Appearance of parties. Or is there another step that I need to take?
Were the appearance forms that were prepared circulated in advance at all to the parties?
Yes.
Okay.
Allison sent me mine, and then I forwarded it back to her.
Okay, so that's all. It's a little different when you're holding it remote than if you were in person and we'd be having people physically sign. So as long as those have been submitted and we have record of the appearances, then you can go ahead and proceed past that, Chairman Michaels.
I have Mr. Meyer and Rachel's. If Mike Shulmus, I think he's in the building. There's some on the table if he needed to complete one.
Excuse me real quick.
I can't hear Sean at all. In fact, he's muted on mine. And so is Allison and Rick.
Turn this up. Can you hear him now?
I think. Let's try it again. Sean?
Try it again.
The form of motion to appear appearance.
No. Can't hear him.
I'm going to turn this up so you can do it.
I apologize.
Okay, I can hear you great now.
Okay.
So don't move.
The motion of appearance has been filed by Jeff Myers, the attorney for Mike Shulmus.
Okay.
Okay. The case in chief, the electoral board may receive written briefs of the parties or oral arguments. The objector proceeds first with their case, and then the candidate, Ms. Rockwell, would be able to respond, and then the electoral board may ask questions at any time, and then we can administer any oaths of office if we need witnesses. I don't think there will be any. So
for the preliminary motions, is that done after this part right here?
And that would be appropriate to do now.
Yeah. Okay, that's what I thought. So I have a motion. I have a motion for dismissal.
okay, please go ahead and state your case.
Okay. My motion for dismissal. I am asking the election board to dismiss the objector's petition, which states that my candidacy for village trustee for the Village of Sugar Grove in the April 6, 2020 election be struck from the ballot. This request for dismissal is based on the fact that the petitioner's objection filed by the objector, Michael C. Shomas, has been amended. According to the 2020 Illinois Electoral Board's Manual, Part 1, Standing Rulings, page 19, Section 2020-3.7, before the end of the objection filing period, no amendments to an objector's petition are allowed, but an objector's petition may be withdrawn and a new one filed before the filing period ends. So I am asking for a complete and total dismissal of the objector's petition based on that ruling in the law through the standard rulings through the Illinois Electoral Board's manual.
Okay. I do not find that there's sufficient evidence to grant the motion of dismissal, so I make a motion that we continue with the hearing.
How is there not sufficient evidence? That's part of the rulings. Objections for an amendment. He's not allowed to amend his document. He's not allowed to amend it. It specifically states, before the end of an objection filing period, no amendments to an objector's petition are allowed. He would have had to have pulled his document before the time of filing and the period ended and put in a new one. It was amended. It is not allowed.
Okay.
If I may,
yes.
I think the question is what, I don't think it's clear to the board what amendment occurred.
Yeah. Okay. So the change is on the first page, section 1. Yeah. So it's section 1 of his. Let me grab it. Give me 1 sec. So in the objector's petition in section 1, where he's stating his residency, the objector amended his place of residency. He specifically states that he's a resident of Wayne Township and came into Village of Sugar Grove, which was my question for Allison, on the 30th and amended it, or brought it into the village on the 30th already amended. And it was time stamped on 12/30/20 at 3:43 p.m. by somebody, I'm not sure, but the document has been amended.
So, Laura, can I? So I can and I think Rachel, what you're referring to is the date that I sent you was the 29th. It was not received on the 29th. It was received on the 30th. So it was Mr. Shomas made that change before he submitted it. It was just he did not want to retype it. He submitted it. It was received by Matt Anastasia, who I had deputized to receive them, and he is the one who time stamped it at 3:43.
Okay, so that's fine. The document's been amended, which it's not allowed to happen. He would have had to pull the document, had his attorney redo the entire document, and it would have had to have been turned in by the end of the business day on the 30th.
Yeah.
And so, Allison, so that was my question. On the document you sent me here, you put December 29th. You're saying that was a misprint on your part. It's actually December 30th.
That is an error on my part. It was received on December 30th.
Okay. It was received amended.
Okay. Mr. Meyer would like to state something for the record.
Mr. Who? I didn't hear him.
No, that's fine. Jeff Meyer, the attorney for Mike Shomas.
Okay.
Okay, my speaker's back on so you can hear him talk clearly.
Can I make sure that you can hear comments?
Can you hear him?
Barely, no.
I'll turn it up and he's going to step a little closer.
Okay.
Can you hear me okay now?
Can you hear him now?
I mean, it's okay. I mean, I can hear a voice. I'm not sure of the detail I can hear, but we can certainly try.
Perhaps, Rick, maybe you switch spots with him and let him sit in front.
Here, I'll turn around.
Can you hear my comments at this point?
I can definitely hear you a lot better.
Okay. In response to the motion, this motion comes in the form of what would be considered it's called a 219 motion, which is one stating an affirmative matter trying to attack the facial sufficiency of the complaint. It's based on an external fact, not one necessarily apparent on the face of the document. Contrary to the argument that's presented, there is no amendment after the fact. This was a revision to the document prior to filing. The document of the law is that you can't modify an objection once it is filed. Your own clerk has just indicated to this board that this document, as presented to you today, is in the exact form that it was at the time that it was filed. There has been no impermissible here. There's no issue of fact on that either at this point because of the comments about this motion.
Well, I mean, okay.
With respect, argument has to go one at a time. You will have an opportunity to reply if the board allows you an opportunity to reply. I didn't interrupt your argument. I'd ask that you please don't interrupt mine. But I'd ask you to. Thank you.
No, all I was going to say is you're cutting in and out.
Okay.
Is there any questions?
I barely heard anything.
Any
Yeah, I barely heard anything you said.
Rachel, could you please repeat that?
Can I repeat that I barely heard what he said? Can you hear me?
If you would.
All right, we're going to let him try again.
Okay. Thank you.
Did everyone hear my comments?
I mean, we can hear, I mean, I don't know about everybody else. I'm only going to, talk for myself. I interrupted you because I was having a hard time hearing you. So I heard some of the things that you said. I think you were arguing that something about the amendment or, it doesn't fit within.
I'll restate my argument because I don't want there to be confusion about my argument and I want you to be able to hear it, obviously.
Okay.
I've stepped a little closer now and trustee, is it Montaldo? Montaldo has stepped back a little from his position here. Can you hear okay at this point?
I can.
Okay. What I said is that the law on this issue is that an objection cannot be amended once it is filed. The clerk's comments make clear that there is no issue of fact here about whether or not this objection was modified after it was filed. The clerk's comments are that it appears today before this board in the same form that it was received from the objector. There has been no amendment to this objection after filing. There is no rule, nor does the law say that you cannot mark up, modify, revise your objection before the time that you file. There's a typographical error on page 1. It was corrected prior to filing. If we needed testimony from my client on that, we could certainly swear him and have him testify to that. But I think the clerk's comments make clear already. It's in the form that it was at the time it was filed. There's been no impermissible amendment to this objection prior to filing or after filing. And this motion.
Okay. I think you did a decent job. Oh my goodness. I'll wait for all the banging to stop. Okay. Can everybody hear me? Everybody can. Okay. So I think it's pretty clear in the Electoral Board's manual of standard rulings before the end of an objection filing period. No amendments to an objector's petition are allowed, but an objector's petition might be withdrawn and a new one filed before the filing period. At the end of the day, when this was filed and it was amended, first of all, no amendments are even allowed to be made, but this is a mandatory area that he had made the amendment. This is, for instance, Mr. Thomas at the time was he lived in Wayne Township. He was in Sugar Grove Township. So I think it's pretty clear in the objection has been amended clause of the Electoral Board's manual, Part 1 standard ruling, that there are absolutely no amendments in an objector's petition are allowed. They're not allowed. An objector's petition might be withdrawn within that period of time and redone and a new one filed. before the period ends, which means he would have had to have brought this document in, not living in Wayne Township, which is a mandatory requirement by Illinois state for elections, is stating residency. At the time of filing, he was a Wayne Township resident, and he amended it, which is a required field, to state that he lives in Sugar Grove Township. So that is my motion for dismissal. It's based on law and fact, and it's a mandatory field.
Okay, can I ask a question, Laura? Okay, my question is, I'm seeing this. I understand what Rachel's saying argument-wise, but I'm also understanding that an amendment would be something after it was given to the village, and this particular document was corrected prior to it being given to the village, so it's not technically an amendment. It would be like a Scribner's error or something that they had typed something wrong, they corrected it before that. So it's not technically an amendment at that point, right?
Well, it's up to the board to apply the facts of this case to the law. The rule with regard to amendments is generally that you can't amend a complaint after the filing period has or after the objection period has concluded. So after that 5-day period in which they can file an objection has concluded, whatever has been filed is what's on the record, and that's when that time frame ends. So how you want to apply these facts is within the discretion of the board.
Okay. Hold on. In the 5-day period, what are the date frames that we're looking at? That you're talking about, the 5 days. 5 days from the date that it's filed, or 5 days from the date that Rachel turned in her paperwork?
Are you asking me? I'm sorry, Rick.
No, I was asking Laura.
Oh.
The 5 days you're talking about, is that 5 days from Rachel turning in her? I'm asking Laura, Rachel.
From the paperwork.
Okay.
From the time Rachel turned in her paperwork.
Correct.
Which was on what date, Allison?
No, the objection window goes from 5 days following the closing of the period to receive them.
Yes, I'm sorry, yes.
Which would have been on Monday the 21st, because we were closed on the Thursday and Friday. The ending time was the 30th, and it would have been at 4:30, and this was received within that time.
Okay.
Okay. Yeah, that's not what I'm arguing.
So, can I make a motion to deny or motion to dismiss?
No, you can't, because I'm not even talking about the filing period being expired.
Excuse me, Mrs. Rockwell. I have heard your argument. I am, as the electoral board member, I am making a motion to dismiss the motion not approve or deny the motion to dismiss.
Based on the Illinois board's standard rulings, you're filing a petition to not hear what I'm saying, because a minor change or addition designed to approve a text, piece of legislation, etc., is an amendment. And this is part of your standard rulings.
Motion.
What I'm saying is that there has nothing to do with the filing period. Nobody's arguing that he went past that period. That has nothing to do with what my dismissal request has to do with.
Excuse me, Rachel. We have a motion and a second. Please do roll call on this motion.
Clerk Murphy, aye. Chairman Michaels?
Aye.
And Trustee Montalto?
Aye.
Okay. The motion to dismiss is, or the request to dismiss is been struck. We'll ask that the objector proceed with their case.
Well, and from a legal perspective, that is my case, but the rest of it is really just pretty much.
Excuse me, Rachel.
Oops, hold on.
The objector is Mr. Shelmus and his attorney.
Okay. Tommy, I'm gonna need help with this computer. Well, like the thing is coming back on here.
Okay, I am unmuting again, and I'm spinning this around so that the attorney can speak again. Yep. Okay.
Yeah.
And again, I want to make sure that everyone is able to hear my comments. Is the candidate able to hear my comments?
If you're asking me, I can hear you for the most part.
Thank you. I'll try to speak loudly and clearly as much as possible.
If you would like to remove your mask,
Okay, yeah, with the board's permission, maybe this will help a little bit. This is a relatively straightforward objection. Most of this is an issue of law, I believe, but there is one issue of fact, and for that reason, I've asked the board, please swear the candidate. I'd like to ask questions under direct examination.
I didn't hear the end of what he said.
Okay. Rachel, I need to, we need to swear you in as a potential witness.
Okay.
Laura, do you have the oath for a witness?
Yes, and we would ask that you raise your right hand and state under oath that you swear or affirm to tell the truth, the whole truth, and nothing but the truth for the purpose of this proceeding.
I do.
Okay. Consider yourself a witness.
Okay. Please proceed. Thank you. As a preliminary matter, I would ask that the board please take notice of and admit into evidence the call, the affidavit of service or waiver of service, appearances of the objector and candidate, the objection itself, and also the candidate's nominating papers, both the statement of candidacy, loyalty oath, nominating petitions themselves. I'd ask that the board take notice of those and that they be admitted into evidence.
Do I need to make a motion on that?
Those can be approved by the chair. However, the board as a whole can also act to act on that.
Okay, well,
go ahead, Rick.
I'll make the motion that we approve those as evidence.
Roll call.
Trustee Montalto?
Aye.
Chairman Michaels?
Aye.
And Clerk Murphy? Aye.
Thank you. At this point, I'd like then to begin my direct examination of the candidate, Rachel Rockwell. So I'd please like to call her as a witness.
God, it's so hard to hear him.
Okay, Rachel. Mr. Meyer is going to direct questions to you.
Okay.
And because of the technology issues, I'll make this very brief and dispense with what would otherwise be some foundational questions. But Ms. Rockwell, you have filed village clerk for the village of Sugar Grove nominating papers to be a candidate for the office of village trustee. Is that correct?
It is.
Okay. And do you have papers in front of you, President?
Is he asking me if I have my papers?
I have asked you if you have a copy of your nominating papers in front of you, President.
No, they're not exactly in front of me. They are not.
Okay. Do you have a copy available to you?
Do I have a copy of the motion that you guys filed in front of me? Is that what you're asking?
Of your nominating papers.
The nominating
Your
papers?
petition. Yeah, your petition papers.
Yeah, I mean, it's probably upstairs. I don't have it in front of me.
Okay, with the chair's permission, I'd ask that the witness retrieve a copy. I'd like to ask you some questions regarding that document.
Do you need a recess real quick to get those?
I asked my husband if he would go upstairs and see if he can grab them.
Yes. I'll ask a couple of questions while if she has them.
The blind. Can't see anything. Is this both copies? Okay, what specifically do you want me to look for?
So you have a copy of your nominating petition in front of you presently, is that correct?
Hold on. Right now I have copies of my signatures. Am I looking at my signatures?
Yes, you filed a nominating petition that has what appears to be 18 pages of nominating petition signatures, complete signatures, correct?
Yeah, that sounds about right.
Okay. The copy that you have in front of you, are they paginated, meaning are they numbered at the bottom?
Yep, they are.
Okay. I'd like you to please take a look at the sheet that is marked sheet number 1. Do you see that?
I do.
At the bottom of the page there is what they call a circulator's affidavit. It starts with I, Rachel L. Rockwell. Do you see that?
I do.
Okay. It says, I, Rachel L. Rockwell, do hereby certify I reside at 1731 Hannaford Drive in the city, village, or unincorporated area of Sugar Grove, 60554, County of Kane, State of Illinois, that I am 18 years of age or older, or 17 years of age and qualified to vote in Illinois. I'm a citizen of the United States, and that the signatures on this sheet were signed in my presence not more than 90 days preceding the last day of filing the petitions. Do you see that?
I do.
Okay. There, underneath that section, there's a signature, and it appears to be the signature of an individual named Bonnie. Is that correct?
Yes, it is.
You did not circulate the petition sheet. Is that correct?
No, she was my circulator.
None of the signatures that appear on the page were signed by these voters in your presence. Is that correct?
That is correct.
Okay. You would now please go to page 5. Or pardon me, sorry, page 6. Page 6 of your nominating petition. Do you have that in front of you?
I will in just a moment. Okay, I have it.
Okay. And again, this has the same language that I, Rachel L. Rockwell, and then so on and so forth, that these were signed in my presence, correct?
Correct.
Below that, there's a signature of an individual that appears to be, and I don't know the last name, but the first name is Angela, correct?
It is.
Okay. You didn't search this, did you?
I did not.
None of these signatures were signed by voters in your presence, correct?
Correct.
Okay. Same thing on page 7. And I'll dispense with the precatory question. I'll just move on to where it's got your name, but then it's signed by Stephanie Myers as the individual who signed this part of the notary, correct?
Correct.
Again, you didn't circulate the petition sheet, correct?
I did not.
None of these signatures were by voters in your presence, correct?
Correct.
Same with page 8. None of these petition signatures were signed in your presence, correct?
Correct.
You didn't circulate this page, correct?
No, I did not.
Page 10. You did not circulate this petition sheet, correct?
On page 10?
On page 10. Pardon me, page 9.
Yeah, no. Did you say page 9?
Page 9.
Yes, that's correct.
Okay. And you didn't witness any of these individuals sign this petition sheet, correct?
Correct.
Page 10. Same question. You did not circulate this, correct?
I did not.
None of these signatures were signed in your presence, correct?
Correct.
Page 11. You did not circulate this sheet either, correct?
Correct.
None of these signatures were signed in your presence, correct?
Correct.
Page 12. You did not circulate this petition sheet either, correct?
Correct.
None of these signatures were signed in your presence, correct?
Correct.
Page 13. You did not circulate this nominating petition sheet either, correct?
Correct.
None of these signatures were signed in your presence.
Correct.
Page 14, did not circulate this petition sheet, correct?
Correct.
None of these signatures were signed in your presence.
No, they were not.
Page 15, you did not circulate this petition, correct?
Correct.
And none of these signatures were signed in your presence, correct?
Correct.
Page 16, you did not circulate this petition sheet, correct?
I did not.
None of these were signed in your presence, correct?
Correct.
Page 17, you did not circulate this nominating petition sheet, correct?
Correct.
And none of these were signed in your presence, correct?
Correct.
Page 18, you did not circulate this nominating petition sheet.
That's correct. I did not.
And you did not make signatures signed by the voter here on the sheet, correct?
Correct.
I don't have anything further. In addition to the examination witness, I would like to submit as an offer of proof. Now, we've pled it, and it was not attached by omission to the nominating petition itself. And I'm not asking to amend the nominating petition. That ad nauseum, exhaustive of the law is regarding. Notwithstanding that in our objection, we do raise the issue that there are certain signatures that are invalid under election law, and I submit as Exhibit 1 an appendix of line-by-line objections and the nature of specific lines and signatures we would object to on that basis. I'd ask that that be admitted into evidence. Okay.
Mr. Chairman, I'll accept this. I'm listening to election. Yeah.
In light of evidence before the board, I'm prepared to make an argument if it's appropriate for the board at this time, if you'd like me to proceed on that. The objection we've raised here raises a couple of things. First, it states that there is a mandatory provision in the election code that appears in section 10.4 of the code that sets out some certain requirements for a circulator's affidavit. Circulator's affidavit on a nominating petition sheet is an attestation by the person who purportedly circulated that to voters, attesting to a number of things. One, that who they are, where they live, that they are genuine signatures of voters on that nominating petition sheet, that they believe those voters to be qualified for the time that they circulated this petition. And that circulator's affidavit then must be signed by the person who circulated the sheet, and it must be then sworn to before a notary public. What we have here is one of either three things. First, it is either a violation of that mandatory provision of the election code because, as testified to by the witness, it says that the candidate, on its face says the candidate is the individual who circulated sheets 1 and 6 through 18, but that's not the case. The sheet was actually circulated by some other individual. So either that statement is inaccurate or it is untruthful. If it's inaccurate, then the code hasn't been complied with because its requirement is that it contained information in that paragraph about who actually circulated the sheet. And there's a good reason for that. The reason behind the circulator's affidavit requirement is so that if there's ever a question as to the veracity of whether or not the signatures are genuine, really collected by the person whose signature appears on the sheet, we know who they are, we know where to find them. If you don't put the circulator's affidavit, it's very difficult to ascertain where the person who attests that they circulated that sheet, where they really live. We don't necessarily have that in this case without resorting to looking at other places for that information. That's problematic. That's the reason behind that mandatory. So either have information the code requires in a mandatory provision, or we have an affidavit that is false. It needs false information. Now, maybe this is a rare pre-printed form. I don't know. And maybe the candidate can give us some information about that. But it matters not. It matters not. These are mandatory requirements of the election. You guys have in there. And if you don't, that's a big strike the candidate's nominating petition. But if we accept these documents true on their face, because they're still affidavits, there's still a statement under oath by these various individuals. Got Lisa Bonney, you have Angela, and I don't have her last name, Stephanie Myers, Jason Mann, Angela Spears. There are a number of people in here, Debbie Ray, Jennifer. All of these people have signed an affidavit saying that Rachel Rockwell is the individual who circulated these nominating petitions. Now, I don't know if they didn't read what they signed, but it's still a statement under oath. It's still a pattern of false swearing. Election code and the applicable law is pretty clear that a pattern of false swearing invalidates your nominating sheets. Sometimes people make mistakes, and maybe that's what happened here. But innocent mistake, not innocent mistake, either way, it's either a violation of the mandatory provision of the code because the requisite information is not contained on the face of this document, or these are unlawful affidavits. Either way, these nominating petitions should be stricken. In support of the argument, or in support of that argument, I do have some citations of authority, and your counsel, I presume, have copies of this, but I do have copies as well, and I can leave them if that's helpful to the board. There's a case out of the first appellate district. It's Cunningham v. Shaflin. That's 2012 IL App First 120529. What happened in the Cunningham case was that there were objection raised to circulators' affidavits because of the transcript numbers in the circulator's address. Okay? The objector said, well, that's accurate, that's not really their address. The court said, that's de minimis. You still, it was one number was off, the address appeared somewhere else. You could have still found these people. That's not fatal unto itself. But here was the additional fact that caused the problem in the Cunningham case. And that was, there was evidence that the individuals who signed the circulators' affidavits made false statements in them. Principally, that they appeared before a notary public. Turns out, in many of these cases, they had not. And the court in Cunningham said, notwithstanding their attempt to comply here with Section 10.4, you have a pattern of false swearing by these two circulators. You have to strike this nominating petition on that basis. That's what the appellate court held. Jackson Hicks is a case out of the Illinois Supreme Court that came a few years later, and that's Jackson Hicks versus East St. Louis Board of Election Commissioners, 2015 IL 18929. Here's what Jackson Hicks said. Jackson Hicks was looking at the election code, and there was a signature requirement provision. It said, because you have this body of law there about what they call substantial compliance, okay? Getting it close, basically. A lot of candidates would come in and say, like, maybe the candidate does here. Look, this is a mandatory provision, I grant you that, but I'm close. I substantially comply with the requirements of the election code. There's no evidence of fraud necessarily, so no harm, no foul. Okay, I still got my signature. Okay? What the Illinois Supreme Court said in that case is that, no, mandatory provisions are mandatory provisions. You either comply with them or you don't comply with them. This is a yes or no proposition. Either you have the number of signatures required or you don't. Getting close doesn't cut it. In this case, you have a statute in Section 10.4 that says, in clear language, you shall have this information in your circular's affidavit. That circular's affidavit shall be signed by the person that it purports on its face to have been circulated by. That shall be sworn to before the Republic to be a truthful statement. That's all been violated. Simply or purposely, it's still been violated. There is no substantial compliance here because there can't be substantial compliance with the mandatory provision. The candidate's nominating petition, both bases, should be stricken. The relief prayed for and the objector's position should be granted, and the court's time and attention. Okay, I'll open it up to the petition.
I didn't hear anything Sean said.
I will open up the. I'll open up the to the electoral board, Allison, Rick, and myself, if there are any questions for the attorney.
I have no questions.
I don't have any questions either.
I have none. So the electoral board has no questions at this time. Thank you. Okay.
Okay.
I'll open up the floor to the candidate as an opportunity to respond. Rachel.
So there's a couple things. First, I just wanted to kind of revisit the dismissal. I just want to make one last note of it. He is basically the objection to my petition. I just want to clarify a couple of things. So this is pretty standard in these larger towns and cities where people dig through your candidacy papers and they look for what he's calling mandatory requirements. Well, that is also stapling, and it's also numbers at the bottom of the page. So I totally admit that I filled out the circulator's statement, and then I made copies and I passed them out to my circulators. So there's absolutely no argument there. People get thrown off the ballots for the staples and numbers. These are things that people just dive and look for, and they have the legal right to do so. It's not something I would ever do, and it's never been done in the history of Sugar Grove. One time 18 years ago, but that gentleman was a felon, and he was unopposed. In my opinion, as I will state in my opening statement, I believe that the voters should have anybody that wants to run put in front of them, and they decide if I don't win on the merits and the people don't like what my platform is, I'm totally fine, with that decision. Nonetheless, everybody has the legal right and has a strategy of how they're going to get there, and the constituents of Sugar Grove have historically shown that that's not part of their agenda, and they have no interest in the drama. So I will never be pulling candidate papers in order to find paper clips and numbers and misprints and misspellings to file any kind of an objection to their candidacy. The people can decide. So with that being said, I don't really have any legal recourse for what the argument is. It is legitimate. I'm not going to deny that. I just explained to everybody how it got to be, and that is I filled out the document one time, and then I passed it to my circulators. So with that being said, for my circulators, which all have now re-signed the circulator statement and re-notarized and re-dated all of the documents so everything is legal, these 143 signatures matter to these people, and they matter to me. They matter to the constituents in Sugar Grove, who are all voters, or anybody that participates in the process who's a voter. Who wants to have their voice heard, and they want to be able to have access to any and all people running to make their own decision at the ballot box. So I would appreciate just a minute for me. I prepared a statement on their behalf, and I would appreciate just a minute to kind of read that, if that's okay. So, good afternoon, ladies and gentlemen of the Electoral Board, Council, and members of the community. I appreciate the outpouring of support regarding today's objection to my candidacy and the upcoming April 6, 2021 election. I think it is important to make a formal statement regarding this historic hearing to our local community election process. It is 18 years since an objection to candidacy has been filed, and he was a felon and running unopposed. This might be the first with my circumstances in the history of Sugar Grove. I want to emphasize that pulling a candidate's packet is completely legal. It happens in the majority of our surrounding towns and in Chicago pretty consistently. Potential candidates or the public at large having legal access to cross-check all formal documents submitted for technical errors. This affords any person within the jurisdiction of candidacy to then object to a person's candidacy. These errors can include anything from not being stapled and binded properly to misspelling, missing numbers, or other errors. I wanted to explain a bit further because the average person has no idea regarding the process of becoming a candidate. I am a grassroots candidate, heavily involved within the community for 20 years, and I feel this is a historic defining moment in our small town. With COVID-19, the sickness that plagues all of us at some level, people have either had the disease, many who have had loved ones currently in the hospital, alone and afraid of death, and lastly, so many who have actually lost someone dear to them. This burden weighs heavy on each and every one of us. We are all connected to each other in this way. Our kids at home learning, so many struggling families, struggling financially, or complete job losses with no end in sight. Last but not least, our national divide regarding our national election and the massive amount of election fatigue regardless of party. What COVID-19 has taught most of us is we need our neighbors, we need our friends, we need our families now more than ever. Grasping onto each other for support, for food if we are suffering, and maybe a friend to walk outside with to share our frustrations with. All and any of us can truly control is what is happening within our communities. I implore all listening to this hearing today, regardless of outcome, to consider what matters to you when you cast your vote in April. It is my belief of all people should have the right and opportunity to hear all candidates and decide how they will cast their vote on April 6th, based on the merits and the person's platform. Today's hearing, brought on by Mr. Shomas and investigated initially by current village trustee Ted Cook, is the opposite of that. Lastly, I wanted to thank Allison and Brent Eichelberger for working quickly and diligently to gather information, answers, and documents at an expedited level, considering this is all new for them also. While I am not thrilled to be here today, I believe deeply in the rule of this country's laws and processes. Thank you to all who stand where I am unable to stand for my protection of my right to be here today. This includes the Electoral Board I am in before today. That is all. Thank you. So that's all that I have to say. And I speak on behalf of the 143 signatures and every person who lives within this community. This is a historic hearing, and the people are going to have to decide if they are looking for a power grab or if they want change in their community. And it doesn't appear that the rule of law is something that's totally being considered based on, I stated a law totally taken from Electoral Board Manual of Standard Rulings, and it was dismissed. That is your right as an Electoral Board to vote. So I accept whatever your decision is. Everything's on the record, it's recorded, and that's it.
Okay. Is there any questions for the Electoral Board towards the candidate? I have none.
I have none.
I have none.
Okay. Give Mr. Meyer opportunity to make a final comment.
Thank you again. In response to the argument of the candidate, a few points. One, she's alluded to some new circulators, affidavits, or modified circulators, affidavits. They're not before the board admitted in evidence, but even if it had been offered in evidence, we've discussed ad nauseum, can't change an objection after it's filed. You also can't change can't take the work after it's filed. So even if they cleared this up, which again, there's nothing in the record actually today to establish, but even if there was, if that's an offer, for example, I don't think it's properly considered by this board. At the end of all of this, even after response here by the candidate, it's very clear that there is no dispute of fact as to whether or not page 1 and page 6 through 18 of the candidate's petitions violate mandatory provisions of the election code. In fact, it sounds as though that's actually conceded by the candidate in this case. Each and every one of those petitions should be considered invalid, should be stricken, and not considered by this board in determining whether or not the mandatory minimum number of ballot signatures has been obtained by this candidate. When you strike out the pages of the nominating petition that we've just identified, the candidate is left with at most 39 valid signatures. That's less than the 55 minimum signatures required for this office by local law. We did raise, as I indicated, a line-by-line signature objection. I think it's largely moot if this board agrees with us on the issue of whether or not these sheets are all facially invalid. If they're facially invalid, sheets below 55 signatures, there's no need to go to a records examination on the signatures that were objected to on the sheet that she herself circulated. So if the board rules in our favor, there's no need to do that records examination. If you don't rule in our favor on that, there may be an appropriate basis for records examination under Rule 6 of the board's rules. Another argument that was raised by the candidate had to do with motivations. Motivations of an objector or people that are allegedly are colluding with an objector are patently irrelevant. This board's own rules make that clear. Rule 5 that this board just adopted makes very clear that the objector's motivation or personal knowledge of the factual basis for the objections is not relevant to the board and shall not be considered. That's not proper argument. It should be disregarded by this board. I grant that ballot access is an important right. It's one that's recognized by law. It's one that I think normatively we should recognize. But the right to ballot access is not absolute. It's not a matter of I want to be a candidate for office, so I get to be a candidate for office. The rules be damned. There are reasonable restrictions and rules on ballot access, and for good reason. You have to establish a moderate support to be a ballot candidate. If anybody that wanted to be a candidate for any office, there would be nothing but electoral chaos. Imagine a circumstance where 100,000 people in the state of Illinois said, I want to run for president of the United States. I want a whole slew of electors on the ballot with my name. Nobody would be able to. That's a completely untenable situation to have that number of candidates on a ballot. Now, I realize this is a village Sugar Grove in a trustee spot, not president of the United States, but the rule still holds true. If there are no rules, if it's just a matter of I want to be a candidate, I want to be a candidate, and some people say I should be a candidate, I should be on the ballot, there would be electoral chaos. And you can't make exceptions even when you're sympathetic to the plight of a circumstance of a person who maybe made a mistake. The rules are there for a reason, for good reason. And the courts have repeatedly upheld them and said that notwithstanding the fact that ballot access is an important right that should not be lightly taken away, if you fail to follow the mandatory procedure, that's what an electoral board is supposed to do. That's what the courts have said. That's the instruction to this board. I may not like every provision of the law, including the election code. You may not like every provision of the law. But that's not up to us to decide whether or not that's the law of the state of Illinois. That's up to the legislature, it's up to the governor, some degree to the courts to interpret and to clarify for us. And they've done that in this circumstance. We're bound to that law, like it or not. We're bound to that law. And the law in this case requires that the candidates nominate positions that the sheets be identified, be stricken, and validated, and that she have her name barred as a candidate on the ballot. Thank you again.
I have one thing that I would like to rebuttal based on something that he had said. That's possible. Just take me a moment. Can you guys hear me? Oh, well, I can't hear you. Everybody's muted. So.
Yes, we can hear you.
Please proceed.
Then, yeah, am I able to talk?
Yes,
okay.
Please.
Thank you. Okay. So I just wanted to just make one point about, I have a question for Mr. Shomas's attorney. Is he able to provide the dates that Mr. Shomas looked at my candidacy papers?
He's not a witness and not being called as one.
Okay. So he doesn't know. Does the attorney know does the attorney, so maybe the attorney knows this. When did Michael Shomas come in to hire you to put together this objection? What was the date? There's no dates on my documents, so I don't know when it was when he came in and actually sought your counsel.
That's privileged information. It could have been obtained through a number of sources.
Okay, that's fine. So what I wanted to say to this is he's talking about motivation and how important it is for everybody to be able to get to the ballot. What I wanted to say is I filed on the first day my candidate packet first thing in the morning on December 14th. And if he's claiming, if the claim here is that we're trying to protect the integrity of the election and everybody fill out everything appropriately, et cetera, which is fine. Listen, this is legal. I have not argued that anything that he has done is illegal because it is not. It's totally legal and it's done all the time. It just hasn't been done here in Sugar Grove ever in the history. But if he was truly, interested in the constituents, and that was his true motivation, to make sure that all of my signatures were in fact legal and all residents, and he was concerned about that solely, there was plenty of time for him to have pulled my packet, filed the objection during the period that I could have amended any and all of those petitions and signatures, and we wouldn't be here today. So I'm just going to leave that where it is. I don't know his intention and motive. It appears filing it on the very last day when something be filed doesn't give the potential candidate an opportunity to amend anything so that every person does actually have access to the ballot. this really isn't, I don't think, for anybody listening or for my own personal stuff, I don't think anybody really thinks that somebody filing something on the 30th is concerned about everybody having access to all people on the ballot and it being, it's not about that. And so I'll let the people decide that. That's why I had asked about that date. And it's privileged, of course, because we filed on the last day. He had, from the 14th until the 21st, I had until the 21st to file any amendments or anything that would have been open. So from that time, he pulled my packet, or actually Ted Cook pulled my packet, and then told him to file this in his name. I don't really understand what that was about, but again, that'll come out at some point and the voters can make their decision on that. But this isn't actually about access. This isn't actually about the rule of law. This isn't actually about every signature and every person within the community having their rights and their electoral rights being protected. This is about getting somebody off of the ballot over technical errors. I think there's been enough technical errors today to go around, including his own document that had him in Wayne Township, and it was amended after, even though the document, according to law, is not supposed to be amended. An amendment is any kind of change, and that's within a mandatory field, by the way. And so, yeah, I just wanted to state that, and I appreciate it.
Okay. The question comes before the electoral board is limited to the adjudication of the objections that have been raised. As much as we've heard from the candidate as to positions that could be taken, we are limited as the electoral board to consider the objector and the state law that applies. I ask at this time if the electoral board has any questions for our attorney or any of the witnesses, the objector, or the candidate.
I do not.
I do not have any questions.
Okay. Then if Attorney Julian, do you have any comments?
So right now, what the board needs to do is to deliberate in open session. You've heard the evidence presented before you in the testimony. So now you need to deliberate and come to a consensus as how you would like to direct me to draft the final decision of the board, at which time, once you put that all in the record and give me the guidance, you'll need to recess. So to give time to draft that decision, and then you'll reconvene and review the decision and adopt it. So right now would be the appropriate time to discuss all the evidence that was presented and provide me with direction.
Okay.
I'll start. I would. I totally understand where Rachel's coming from, and there's no doubt in my mind that there's no intent to defraud or do anything like that. I think it was an accident. It's easy for a first-time candidate to make a mistake, and I was looking at this as a possible Scribner's error, something of that nature. But the law seems to be pretty cut and clear when it comes to this. I read through the entire electoral board guidelines, and on page 62 of the guidelines, under section 2020-5.4.8.4, it specifically says disagreement of names and certification of affidavit, which is what we're talking about. And it says in there can only be one circulator of the sheet, where the name at the start of the affidavit, example Jack Schwartz, differs from the name of the person who signed it, example Amy Schwartz. The objection should be sustained, and all signatures on that sheet should be disqualified. And they quote Schwartz versus Kinney, 2016 Illinois Appellate Court case. So by law, if we are bound to law, it's my opinion that the objector has a valid argument that these sheets should be not counted. And it's specifically stated in guidelines of the Board of Elections. I truly feel that any candidate who wants to run should be able to run. And Rachel still has an option, if we vote against this, to run as a write-in candidate, which has been very beneficial to candidates on the board in the past. And this has nothing to do with my personal agenda. I'm not involved in the campaign, nor will I be running again. But I'm, with a background in law, I'm pretty much cut black and white while I'm reading the law, and this specifically states that this should be done. So I would be in favor of disposing of the pages that are invalid that the objector has brought up.
I would concur with what Rick just stated.
And I agree with Rick's statements too. In fact, I found the same citing and actually looked up the appellate court case to read through Schwartz and Kinney, and it's pretty clear that while there are opportunities for electoral boards to make considerations, this doesn't seem to be one of the cases where that can be done.
Okay. I will make a motion that the electoral board grants the objection to the petition and direct our legal counsel to draft the findings of fact, and that we will reconvene on Friday morning at 9 o'clock to have those findings presented to us and the electoral board to vote on those findings and that decision.
And to be clear, is Friday the 8th?
Friday the 8th.
Okay, just wanted to be clear for the record.
I have a prior commitment Friday from like 9:30 to 10:30. Is there any chance we can make it a different time of day?
Could we make it at 8:30?
8:30 would be fine. I can make that.
I want to give counsel time to prepare the findings and the motion.
If
8:30 works. That's a first, so I need a second.
I'll second it.
Any
further discussion? Anything, Allison?
Nope. I have nothing else to add.
Okay.
All
right.
Laura,
is there anything else that we need to include in the motion?
Nope, that's sufficient. So yeah, just roll call on the motion, and then to be clear, the board will recess then until Friday morning at 8:30 on January 8th.
Okay. Allison, could you take roll, please?
Sure. Chairman Michaels?
Aye.
Trustee Montalto?
Aye.
Clerk Murphy? Aye.
Okay. At this time, I'll ask for a motion from the electoral board to reconvene to recess until 8:30 on January 8th, or January 9th. Oh, I think it's Friday, January 8th.
I'll make the motion that we recess and reconvene Friday, January 8th at 8:30 a.m.
And I'll second it. And then I have a question for Laura before we recess. On the agenda was public comment.
Oh, yes.
Okay. Thank you, Allison.
Do we need to hold the public comment before we recess?
You can do it either way, but I would advise, since you have probably a number of public participants now that may not attend on Friday morning, that it would probably be advisable to hold it now.
Okay. Rick, would you rescind your first?
I will rescind my first.
Allison, will you rescind your second?
I will rescind my second.
At this time, I'll open up the meeting to any public comments. If you would like to make a public comment, I think you can raise your hand as part of the software and make
Actually,
a comment.
I'm sorry. This is GoToMeeting, so everyone, they're gonna have to just speak up, and I will see kind of whose call wiggles, and we'll figure out who it is. It's gonna be a little messy, but it's totally doable.
If you'd like to make a comment, please do so at this time. Give a second opportunity for anybody to make a public comment. Okay. If no public comment at this time, I will close that portion of the agenda. Okay. All right. May I get yes, please.
All right, I will restate my motion to recess until Friday morning, January 8th at 8:30 a.m.
And I
will second that. Roll call, please.
Trustee Montalto?
Aye.
Village Clerk Murphy? Aye. And Chairman Michaels?
Aye. Okay. Thank you all, everyone, for participating. And at this time, I'll entertain a motion to adjourn.
You don't need any more motions. You're okay to recess now.
Okay. All right. Thank you all. We'll terminate this meeting. Thank you.
Okay, bye-bye.